Good morning, everybody. Welcome to the Commission on Sentencing Boot
Boot
Camp.
camp.
So my understanding is we're going to have a series of 1 hour blocks, 50 minutes of which will be addressed to materials and then minutes for break. And are we starting off with the OGS?
We're going to start with just an overview.
Or Dara says, okay. So I guess I'll turn it over to the executive director in the presentation.
Thanks, Judge, and good morning, everyone. I believe that we do have a couple of members that are participating by Zoom. I believe Senator Langerholt and Attorney Marsico are participating by Zoom. And just for the record, I'll indicate that the members present are Representative Stevens, Judge Bernstein, Judge Dowley, Representative Krajewski, Judge Marsico, Professor Rago, and Judge Tucker, and District Attorney Sunday indicated he's on his way, so he should be joining us soon. As background, during the commission meeting in June, we gave a presentation, an overview of some of the work over the past, well, I guess since 2014, in trying to look at the guidelines and come up with sort of a fundamental rebuilding of the guidelines. And we provided some background at the time about why that was necessary. One of the really compelling reasons was that every year we're doing an amendment to the guidelines, which takes a lot of time, and it keeps pace with legislation, but it really doesn't look at the sort of the fundamental formula of the guidelines. And what we found back in the 1990s, when we did our only other comprehensive review of the guidelines, is that it's an opportunity to sort of take a big picture view of how the guidelines are operating and think about fundamental changes if we think that's appropriate and necessary. So to start that process back in 2014, the commission created a strategic planning advisory committee to look at the guidelines, to bring in outsiders, and to spend about a year or so working with a group of, I think, about 35 individuals from around the Commonwealth to come up with sort of an external view of the guidelines, what works and what doesn't work, what are changes we should be making. And the commission took those recommendations, spent some time working on those, and then about that time, the General Assembly, the Governor's Office, the courts started the second Justice Reinvestment Initiative process. And during that process, there were a lot of changes recommended to sentencing structures and to the guidelines and other things like that. And then just in the last year, our chairman, Representative Stevens, appointed an academic review panel to again look at the guidelines, look at these recommendations that have been developed since 2014, and try to see if there's anything final we should do in terms of race and ethnicity, disparity in the guidelines, things like that, and also just the operation of the prior record score, which was an issue that a number of commentators had raised. And so that committee brought back some recommendations that we gave to the commission recently. And so today, what we wanted to do was spend one day, as the judge said, having sort of a boot camp of doing guidelines. If you're going to rebuild guidelines, what have we learned over 40 years of having guidelines and other states having guidelines? What are the principles that are supposed to be applied in building guidelines? And so we thought we'd spend today trying to talk about that, sort of a deeper dive. So I have a pack of slides that I'm going to go through with sort of some of the fundamentals to think about when we're rebuilding guidelines. And then over the course of the day, Matt and I are going to sort of switch back and forth and cover some issues in a lot of detail, like how do you develop prior record score? How do you develop offense gravity scores? So this is sort of the intro to that. And then as we go through, as I said, we'll be going back and forth. As the judge mentioned, we started preparing this with the idea of almost like a course schedule. we said, let's develop these modules that can be used throughout the day. So we'll have a module right now that's an introduction and overview of guideline development. And we'll have a 1 hour block of which we'll take about 50 minutes to present content and discuss issues. Then we'll take a 10-minute break, and then we'll sort of wash, rinse, and repeat. And we'll do that through the day. So we have 3 of these modules in the morning. We have a break for lunch, creamery ice cream, and then we have 3 in the afternoon. And the last one in the afternoon is really just sort of like, where are we and where are we going to go? What are the next steps? So let me get started with these slides. And here's the rundown of the modules we're going to be talking about. So as I said, I'll talk about some basic concepts and strategies. And then Matt's going to talk about methodology for assigning offense gravity scores. I know it sounds fascinating. It is, but we'll be looking at how we can use some of the data we have as a starting point for assignments. The third module that I'll cover right before lunch is adjustments, like thinking of a different way to simplify or streamline the guidelines. If you think about it right now, we have, I don't know, 6 or 8 different matrices. You know, we had a deadly weapon matrix. We have a matrix for youth and school enhancement. And we have all kinds of other things built into the guidelines that make it incredibly complicated. And so one of the things we've been working on over the years is a way of sort of simplifying the guidelines. And at first blush, it doesn't look any simpler. It looks like we've added a lot of offense gravity score categories. And we're talking about these adjustments, how you move someone up or down the scale. It doesn't sound any simpler. But I think as we go through today's session, as we talk more about this, and especially when you think about entering this into our SGS web application, I think you'll see that that there's some benefits in thinking about this kind of approach. And so our job today is to try to explain what we think would be that approach and to get your feedback and your direction about how we proceed. This afternoon, we'll focus on a couple of other issues on the prior record score, rebuilding the prior record score, and then on basic sentence recommendations. You know, how do you take information about the current offense, information about criminal history, and come up with a recommendation that makes sense, that sort of reflects a typical sentence for a typical offender. And so we want to talk about that. And then, as I said, at the end of the day, talk about next steps. So let's hit some of these basic concepts and strategies. If you spent any time recently reading the guidelines, you'd find this section in 303.11 that talks about purposes of sentencing. And it says that a benchmark for judges in Pennsylvania, a common starting point are these guidelines with a range of recommendations for the typical offender. And I'll stress that typical offender because a lot of times when we're talking about what kind of recommendation we have for a given incident, it's easy to think about a worst case scenario or about a case that you just dealt with that conviction offense or that kind of prior record. And what we have to always ask ourselves is that typical? Because the guidelines are about the typical case. And the reason we have aggravated and mitigated ranges, the reasons judges can depart from the guidelines is there are plenty of times when individual factors drive different sentencing decisions. And one of the benefits of advisory guidelines is it recognizes that there's a lot of benefit in courts considering individual factors of sentencing. But the guidelines are intended to provide that starting point, a common ground for everyone to consider. So keep that in mind throughout this process that we're thinking about guidelines for typical offenders, typical sentence for the typical offender. The guidelines go on to say the guidelines provide sanctions proportionate to the severity of a crime and the severity of the offender's prior conviction record. It establishes a system with a primary focus on retribution, but one in which recommendations allow for fulfillment of other sentencing purposes, including rehabilitation, deterrence, and incapacitation. So that's from our guidelines, and it tries to articulate what our job is when we're coming up with guidelines. So I'm going to hit some of these key points and move us through these fundamentals pretty quickly. But if you look at that quote and look at the history of the guidelines that we've had for, since the early 1980s, the goals of the sentencing guideline have been consistent throughout. And this is found in our enabling legislation. We're supposed to, as a commission and through guidelines, be promoting an effective, humane, and rational sentencing policy. So what does that mean? Well, if you look at the literature and the researchers that have looked at sentencing guidelines around the country, they talk about 3 factors that contribute to sort of rational sentencing policy. The first is that you use guidelines to promote uniformity, that you try to avoid unwarranted disparity. And we've seen that over the history of the commission, where the guidelines are used, again, as that common starting point to encourage judges to start there and then look at individual factors. And what the research has found is whether you have mandatory guidelines or presumptive guidelines, or you have voluntary guidelines or advisory guidelines, doesn't matter the nature of the guidelines. If you provide courts with information about a starting point for sentencing, what happens is courts tend to move towards the middle. And that promotes more uniform sentences. And the idea about uniform sentences is that an individual in a given situation should expect to get the same kind of sentence, the same kind of outcome as a similarly situated individual. You have the same conviction offense, you have the same circumstance, the same background. You should have an expectation that you get some type of same treatment. And what we do with our research when we collect data is try to figure out, is there equal treatment or is there disparate treatment? And when it's different, is it different for a legitimate reason? Is it different because you live somewhere different, or because you're a different race or gender or age? So what we try to do is at least provide a system that's a starting point is thinking about uniformity. The second thing is proportionality. So balancing severity of punishment with crime. And you can think about that just thinking about our matrix, where at the bottom of the matrix, we have relatively minor offenses. And at the top, they're really serious offenses. And sort of on the west side, 0 prior record score is a really minimal criminal history. And then you get to someone who's a repeat violent offender. So we have those 2 axes that sort of help to guide decisions about proportionality, that lesser sentences or sanctions should apply to less serious offenses and those with a less severe criminal history. The third thing is blameworthiness, that we should be taking into account the degree of harm and the culpability of the offender when thinking about sentence recommendations. And this is where you can really get into the weeds, and we will get into the weeds later, but trying to sort of figure out what harm was done and how culpable that offender is, and that certainly relates to the type of sentence recommendation we come up with. So those are some of the common goals of sentencing that tie to a rational sentencing policy, not only in Pennsylvania, but around the country. When we look specifically at Pennsylvania statute, the sentencing statute requires that the commission consider 3 factors, sort of balancing factors, when thinking about sentence recommendations, especially when the recommendation is to confine someone. So the first is protection of the public. The second is taking into account the gravity or seriousness of the offense. And that's based on the impact it has on a victim and the impact it has on the community. And then the third is the rehabilitative needs of the offender. And these are requirements that the commission has in considering guidelines, but these are the same requirements the courts have when thinking about imposing a sentence on an individual. So so we are sort of working hand in glove with the court in terms of trying to come up with recommendations that fulfill or address these 3 areas. So if you look further at our legislation where it talks about the commission adopting guidelines, there's a number of specific factors the commission is supposed to build into the guidelines. So the first is seriousness of the current offense. And we do that in the guidelines through the offense gravity. So Matt will be talking in details about how do you come up with offense gravity scores? What are some of the formulas that you can use to assign offense gravity scores that promote uniformity and proportionality? Second is criminal history. So we deal with criminal history through prior record score. And that's one of the things that we're really trying to take a second look at and really try to sort of think outside the box. In our legislation and in our history as a commission, we've always said that seriousness of the offense is the most serious, is the highest consideration in the guidelines. Everything else is secondary. But if you look at how our guidelines operate, prior record score can result in a sentence recommendation that's 9 or 10 times higher than the recommendation if the person has no prior record score. So that is not consistent with the principle that the most important factor that we consider is seriousness of the offense. So we're going to have some proposals that would make some real changes to that. But you're the policymaker, so you'll have to decide whether that's appropriate or what the right balance is. So serious of offense, criminal history are the two initial factors. Another thing that's included in the guidelines is consideration of criminal behavior. And we often think about that as enhancements, where the General Assembly or the Commission identifies certain factors, not elements of a crime, but factors that contribute to the seriousness of the offense or that are indicators of the individual's behavior. So an example of that would be our deadly weapon enhancement. Someone can commit a crime where possession or use of a weapon is not an element of the crime, but it certainly changes the nature of that crime because someone possessed or used a weapon. And so criminal behavior is one of the factors that we're supposed to consider when adopting guidelines. Those top three really get to structural elements of the guidelines. Recommendations that are for the typical offender, typical sentence. But we know that there are a lot of individual factors that courts have to consider to make an individual sentencing decision. And so the guidelines have to provide for aggravated and mitigated circumstances. And we do that with right now through separate ranges of the guidelines. We're going to be recommending some changes to that about how you calculate or determine those ranges. But we think it's important that courts have discretion to go outside of the standard range and even to go outside of the guidelines as long as the court's articulating reasons for it. And then the final thing, and this is sort of a recent addition to the responsibilities of the commission in determining guidelines, and that is taking into account the impact of the guidelines on total confinement. There are many other sentencing commissions that have always been required to consider resources or level of incapacitation as part of its guidelines. And we have traditionally not had that responsibility. But in recent years, our legislation was amended to require that we at least identify the resources necessary and look at any kind of changes in the impact in the use of total confinement, whether at the county level or at the state level. So resource utilization is a new factor that comes into play. And it's one of the reasons we wanted to take a closer look, especially at prior record score in terms of incarceration rates. So aside from those factors, there are also risk-related adjustments that were recently added to our legislation. So our enabling legislation now explicitly indicates that we should be looking at risk-related adjustments. And that could be found in terms of incapacitation of serious and violent offenders, something we've done in the past with the REVOC category, repeat violent offender. But almost on the other side, the General Assembly has encouraged us to make modifications that reflect reduced or increased risk to reoffend. So one of the things that we've talked about in the past was what if someone has a really stale prior record, that they haven't been involved in the criminal justice system for a long period of time? The commission in the past thought it was difficult to remove those prior convictions from the prior record score, that there might not have been authority to do that. But recent legislation linked to JRI 2 provided that the commission can in fact look at modifications to prior record score or sentence recommendations that take into account reduced risk. And one measure of reduced risk is long periods of law-abiding behavior. But the other side of the coin is that if someone's a pattern offender, if someone has a series of offenses and things like that, increased risk to reoffend can also be considered in the guidelines. So these are some new provisions that the commission can consider when drafting guidelines. Here's some like quick bullets that are guiding principles for how our guidelines operate. First and foremost is that we have advisory guidelines. They're not presumptive. And advisory guidelines that provide a common starting point for sentencing. The purpose is to promote similar sentences for similarly situated individuals. The conviction offense is the most important factor that's supposed to be considered in the guideline recommendation. And when we're adopting ranges, we're basing those ranges or those recommendations on the typical sentence for the typical offender. There are two things that the commission has traditionally looked at when setting guideline recommendations. The first is the disposition of the case. In some jurisdictions, they call it the in-out decision. Are you in prison or out of prison, right? So the first question the commission should have when drafting guidelines is, what is the disposition of the case? Is this a case that we're thinking is appropriate for restorative sanctions, things like fines, costs, restitution, guilt without further penalty, community service? Or is this a case where community supervision like probation is appropriate and is not a risk to the community? Or is this a case where jail or prison is necessary or appropriate? So that first sort of level of review in developing guidelines is trying to figure out which disposition fits. One of the weaknesses of our current guidelines and sort of the history of our guidelines is in an attempt to provide a lot of latitude to court sentencing, we also weakened our recommendations around disposition. So if you look at some aspects of our guidelines, our current guidelines, you could have an individual who, for the standard range, aggravated and mitigated range, the three of those together, the court could impose guilt without further penalty or a state prison sentence, and they'd all be within the guidelines. Because the appellate review of the guidelines includes the standard aggravated and mitigated range. So when we're providing a recommendation that allows everything in terms of disposition, we're not giving a lot of direction or guidance, which is fundamental to the guidelines. And we're certainly not promoting uniformity, proportionality, those other kind of issues we talked about. So one of the issues that came up during JRI 2 and one of the suggestions to the commission was to have more focused recommendations that really do focus on a given type of disposition as the starting point. Is this a case that seems most appropriate for probation? Or is this a case that seems more appropriate for jail or for prison? So to the degree that that's practical and appropriate, thinking about disposition first. The next the next aspect of guidelines is then the duration. And as you all know, our review of duration has been expanded. It used to be just about duration of confinement, where we'd make decisions about, is this a case where confinement would be restricted to county jail or it would extend to state prison? More recently, the commission has been given a mandate to adopt probation guidelines. not only about the duration of probation, but also the intensity of probation. And so those have been built into the guidelines. But it just gets to the point when we're building these guidelines, we're going to be thinking both about what type of sentence is being imposed, what's the disposition, as well as what's the recommended duration. And in both cases, at least the recommendations that we're going to be bringing to you are much more focused on a given disposition and a tighter recommendation regarding the duration, in hopes of trying to promote uniformity, proportionality, and sensitive to resource utilization. We have advisory guidelines, and therefore the appellate review we have is weak. And although I guess the biggest area of appellate review is procedural, did courts abide by the guidelines? Did they consider the guidelines? Did they calculate them correctly? And so forth. The substantive review is pretty weak, manifest abuse of discretion. And that's only if you're outside of the guidelines. So really not much appellate review in terms of the recommendations themselves. Some have said that that's an indication or that's an opportunity to provide more specific guidelines because there's not much fear of being remanded, but it could provide better direction to the court or better recommendations to the court. And finally, on the requirements, the guidelines must be considered by the court and sentences must be reported to the commission. And we use this information to prepare recommendations for your consideration when we get to looking at the guidelines specifically. So more on that later. So we've talked about this before, but the question is why now? Like, why are we working on the 8th edition and why a big change to the guidelines at this point? Well, it just didn't start now, right? We've been working on this for a while. But keep in mind that the 7th edition guidelines that we adopted in 2012 were pretty solid guidelines, from pretty substantial changes embedded in those guidelines. And then since then, we've done 7 amendments or supplements to the guidelines almost every year. In 1 year, 2, an amendment and a supplement. So, that's clearly keeping pace with legislation enacted with mandates to do enhancements. But it also shows that the guidelines are not very flexible in terms of incorporating changes in legislation, that it requires us to go through this tedious process to build these things in. That's not great for practitioners either, because it's another set of guidelines, another year, because the guidelines move prospectively. So, it makes sense to take stock and to try to see if there's a better way to do this. And that's what happened during the comprehensive review of the guidelines. Aside from the guidelines themselves, the sentencing guidelines, we also spent a lot of time on the sentence risk assessment instrument. And what we came away from that process with was not recommending tougher or longer sentences or things like that. We came away saying courts can benefit from having better information, more detailed information about the individual to make individual sentencing decisions, to use research on what works, and to have good information at the time of sentencing. And because we can't do that in every case, we just don't have the resources to do that in every case. There's a lot of benefit in trying to target cases where you get a return on investment, where if you provide useful information, good information to the court, it can make a difference in that decision. It can make a difference for public safety, but it can also make a difference in terms of outcomes of the case, better outcomes for offenders, better outcomes for communities. So we, I think, have to think about how we can promote better information in those cases where it'll make a difference. And at least the commission's entree into this area has been with this risk assessment instrument. Let's identify these outlier cases that are high or low risk. And let's say that those are the ones where it's worth the effort, slow down the process or get more information to make a better decision and get a better outcome. So as we think about this comprehensive review, I think about like the two big projects we have as sort of bookends. We started with the strategic planning work group in 2014. They came up with a bunch of recommendations that I'll highlight. And then in between, we had a lot of review of that by the commission. We had some outside reports by students at Carnegie Mellon and Drexel University School of Law. We had the justice reinvestment legislation and the recommendations from that working group. Then we closed recently with the academic review panel, where we really took a close look at things like racial impact and use of incarceration and duration of things like probation. And so, we're bringing to you a bunch of recommendations that we just didn't like think up on our own, but that have been built over a number of years. And if you look at the strategic planning work group, you know, some of their takeaways were that we need to come up with a system that's focused on streamlining the process, simplifying the process, and increasing certainty. And this was, you know, one of those kumbaya moments of both the defense and the prosecution. Everyone's saying, look, we're negotiating pleas all the time. In Pennsylvania, at least what we see is, you know, 90, 95% plea negotiations. But sometimes there was no confidence in what you were getting out of that plea. You would have such wide range to the guidelines. If the pleas were to the standard range, it you know, could have been state prison or it could have been county jail. And if it was a plea to something within the guidelines, as I said before, it could have been from guilt without further penalty to state prison. So both sides said there would be benefit in having increased certainty. And the way you get to that is better targeting of both the disposition and the duration. Tighten the ranges, have more ranges, and negotiate to those issues. So those were some of the key takeaways from the strategic planning work group. And they talked about the need for efficient and effective use of correctional resources, that, you know, we're not made of money. And the idea is when you have an expensive facility or service, we should be figuring out how to use that the best, how to get the best return out of that investment. And so I think the recommendations out of the strategic planning work group included things like increasing the number of offense gravity scores. So you'd have many more specific recommendations that were much more targeted. They also talked about reducing the impact of prior record score. Their view was an important missed opportunity was lapsing, where stale records are removed from consideration the prior record score. So they talked a lot about that as an aspect of prior record score. They also talked about the need to standardize how we do things like enhancements and how we treat aggravating and mitigating factors, that we need to come up with sort of a shorthand that, you know, if you see that there's a really high degree of mitigated sentences for something, we should have a better idea of why courts are always mitigating in that case. Are there common factors? And should we build that into the guidelines so that you have recommendations that take that into account? If it's important enough that it's consistently used as a mitigating factor, then you'd promote uniformity and proportionality if you build it into the guidelines as a factor, as a determination made by the court. So those are some of the takeaways from the strategic planning work group. The academic review panel just finished, built on those, and they talked about promoting fairness and equity through individualized sentencing. So they appreciated the benefits of having a framework that was fair and a framework that took into account a lot of the factors and revisited prior record score. But they also indicated the importance of individualized sentencing by improving the quality of information courts have and improving the services available or to the courts to use. So they talked about, you know, looking at all the purposes of sentencing, not just retribution, not just punishment, but trying to see if there are ways of expanding consideration of other purposes. They talked about that in terms of building community-based programs that might be provide better hope or promise for effective outcomes. They thought there was a lot of information that could be made available to the court that isn't. Things like Sexual Offender Assessment Board reports, which are not consistently provided to the court, depending on the county. Pre-sentence investigation reports that include risk and needs and responsivity information, other information like that. And they also raised a lot of concerns about juvenile and youthful offenders. They raised concerns about how we use juvenile adjudications as part of the prior record score, and they raised concerns about the types of dispositions and sentences that apply to individuals in that sort of youthful age, let's say 16 to 25, because you have kids that are certified or direct filed, and then you have younger adult offenders, and that, you know, whether it's brain science or other kind of reasons, that there's this cohort, this group of offenders that we have to give some second thought to how do you deal with them in the criminal justice system, and are there differences that we should be looking at and considering, because you know, that's how you can have an impact in changing behaviors. So let me start to wind this down by sort of introducing some of the concepts we have, and then introducing what Matt's going to cover next. So when we start with thinking about the proposals we put forward, you're going to see in your handouts another very colorful matrix. This one favoring green and blue, apparently, but the new matrix you'll see has a lot more offense gravity score categories. We have 35. From 1 to 35 are the sort of traditional offense gravity score categories that cover offenses up through murder 3. So misdemeanors and felonies coming before the courts. But we also have 6 separate categories that capture murder 1 and murder 2. So it addresses particularly the you know, those murders by individuals under 18 years of age, but we build into it the regular dispositions for murder 1 and murder 2. The second thing that's different about this is the prior record score. You'll see there are now only 4 categories in the prior record score. And Matt will be explaining this afternoon just a totally different approach to prior record score. What we found, you know, sort of at a very high level is prior record score. We have a lot of categories right now, but the categories don't, some of the categories overlap, and some of them don't have sort of meaning in and of themselves. We're blending a lot of people into a category, and numerically maybe it makes sense, but from the sense of who is that offender or what's that criminal history, it doesn't make much sense at all. It's also sort of this false sense at times that details like that matter a lot. What we found is that having simpler, more categorical prior record score approach might be more helpful, both in terms of seeing this sort of stair step in terms of recidivism rates, but also in just treating offenders more appropriately. And one of the recommendations that's new to this mix is that we've incorporated what we consider a 0 prior record score. One of the recommendations we've heard from commission members in terms of a pure 0, and then a low, medium, and high. And the high would incorporate what we consider those serious violent offenders, RFL and REVOC offenders. So more about that later. Talked about the sentence recommendations. If you look at these recommendations, we'll talk more about it this afternoon, we're much more focused on disposition-based recommendations. These are, you know, recommendations for probation, or recommendations for jail, or recommendations for prison, not for all 3 for a given circumstance. And then durations much narrower, so you have much more focused recommendations. The final thing about this is trying to simplify how the guidelines operate. And by sort of using this matrix as a one-stop shop for adjusting sentences to take into account various factors. So because you have many more offense gravity score categories and you have much tighter ranges, there's an opportunity to identify weights that you would give to factors. And as an example, let's say you say a deadly weapon enhancement, possessed a deadly weapon is worth, 1 step. Well, someone that starts with a base assignment of OGS 10 would move to an 11 because the deadly weapon enhancement was present for possessing a weapon. Some of the hard work of this effort is to really sort of figure out what all the metrics are for this. But what we're trying to present today is sort of an outline of how this could operate and how we think it could simplify the process. So today it's sort of conceptual, and to see if there's buy-in, and if there is, then we can start putting some more detail into this in terms of what are the OGS assignments, what is the prior record score detail, and what are the recommendations that flow from that. I'm going to close this out pretty quickly by just mentioning 2 approaches to preparing guidelines, because I think you'll see this in place today. When commissions think about building guidelines, one of the approaches they can use is called a descriptive approach, where they're just basically using data. They collect information and they use it to analyze what the typical sentence would be. And we'll spend a lot of time talking about, well, what is typical? How do you figure out typical? But if we get 100,000 sentences a year and we have years and years of data, we can start looking at what type of sentences judges gave for simple assault or 0 prior record score in this kind of circumstance. And we can use that data to try to say, well, here's the typical sentence for that type of offense. I looked through last night the number of OGS assignments we have. We have 2,329 right now. So there's, if you just look at our drug offenses, there's 1 conviction offense, PWID, possession with intent to deliver, A30 in the Drug Act. We have, 50 categories for that because we break it down by what the drug is and what the quantity of the drug is and whether it's first or subsequent and all kinds of other issues. So what we need to do is come up with a game plan for assigning offense gravity scores so that you as the commission don't have to go through 2,329 individual offenses to decide what OGS you're going to give it. But if we can have rules of the road, and if the rules of the road are based, at least initially, on what we know in the data, what the data tells us about what the typical sentence would be, if we use that as a starting point, that may help us in the process. So we're going to talk a little bit today about a descriptive approach. Matt's going to give you an example, walk through examples of using our data to sort of figure out what the typical sentence might be and see if that makes sense. And if it does, we can at least do that to start the process, to sort of plug in initial values for offenses based on what judges do at sentencing. I just have these pretty graphs here because I'm supposed to mention 3 different ways of measuring what's typical. And if you had any stats course, and you might have run away from this, but there's like 3 measures of central tendency. You hear about mean, median, and mode. And at the top of this sheet, I have a little extract from our annual report, because we report out every year on all the sentences reported to us. We focus on the most serious offense of a criminal incident, and we say, well, what sentence did you get for that? What was the most serious sanction that was imposed? And what was the duration? And we do that for all sentences. And so in the annual report, at the top, you'll see there's 86,000 individual incidences that we're reporting on, where the most serious offense is what we've reported on, and the sentence imposed on that. And we provide sort of the frequencies or the distribution of these sentences. So you'll see 12%, and this holds pretty steady every year. About 12% of those cases get a DOC sentence, Department of Corrections. And then you move to county jail, that's about 30% of the cases. You move to probation, that's about 43% of the cases. County IP, which is now restrictive conditions of probation, is another 12%. So these are pretty consistent things from year to year. So we know the percentage of cases that are going to go to various dispositions. But the other thing about this is we include the mean sentence. What's the average sentence that was imposed in those cases? And here's the problem with the mean sentence as using it for typical sentence. There's a mean sentence for state prison. There's a mean sentence for county jail. There's a mean sentence for probation. There's a whole bunch of mean sentences. There's not a single mean sentence. And that creates a little bit of a problem if we're saying for this offense, what's the average? Well, we don't have an average. We have a bunch of averages depending on the disposition. So mean can be very helpful, but not particularly helpful when you're trying to build guidelines and say, well, what's the typical sentence for this offense? At the other end of the spectrum is the mode. Mode's the most common, most popular incident. So, you have 100 sentences reported and, 50 of them had a 1-year minimum sentence and everything else was way less than that. Well, 50 is typical, but we don't know if 50 is the middle of the pack or if it's just, that's a spike. That's, just something that happened there. So mode's really good at talking about the most popular one, but it isn't necessarily the average. So our sort of favorite in this race is median. It's the midpoint. You line up all of the sentences reported and you find the 50th percentile and you use that value because that gives equal weight to all of them. It doesn't neglect things that are zeros. It doesn't only look at the most popular kid. It looks at everything, gives it equal weight, lines it up. And so when Matt's going to talk about looking at the guidelines and thinking about typical cases, he's going to show you information on the median because we think the median is probably a good starting point. Might not be the last point, but a good starting point. So let me hit final way of thinking about guidelines, and that is what we call prescriptive guidelines. So if descriptive is taking data and using that to sort of come up with sentence recommendations, prescriptive guidelines is when you're making policy decisions. You're trying to make sense of this. You're trying to tell a story. You're trying to say these kind of offenses like serious bodily injury are way more serious or different or should have longer sentences than these that are just bodily injury. And sometimes the data doesn't line up with that, but you looking at it from your experience say, these things should hang together. It doesn't quite matter what individual sentences were given. These types of things are appropriately classified together. So think about getting information where there's inconsistencies. It just doesn't make sense, or you have no data at all. Well, you want a framework to come up to use to come up with the assignment of offense gravity. And so that kind of policy approach is called prescriptive, where you're using your common sense and sort of principles to come up with how you would assign offense gravity. So that's really helpful and sometimes necessary if you don't have any data. The bottom line is it's probably a hybrid. It's necessary to consider both. And so that's what we'll be talking about today, about using the data as a starting point and then looking at other kind of factors, seriousness of the offense, harm to the victim, other things like that, to try to sort of finesse or come up with a big picture, a game plan moving forward. So Matt will be starting our discussion on that a little bit later. So here's what we're going to do. We're going to take a break now for 10 minutes. We're going to then, oh, yes, right. Sure, please.
All right, thank you, Mark.
Sure.
I just had a couple of questions based on one of the earlier slides, if that's
Sure.
okay. It's the one that was about the purpose of sentence and just kind of the like statement around the purpose of sentencing. And I was curious about, I guess sort of in this, and maybe we'll get into this when we talk about prior record score generally, but I was just curious about the origin of that. When did we decide that prior record score is something that we would consider in sentencing? And then I'll just throw my second question here too, so we can get to the break. And then also, when the sentencing purpose said that the primary focus is retribution, and the academic review panel, given these recommendations, did it also include any findings about how that focus on retribution versus considering rehabilitation, deterrence, et cetera, how that has impacted sentencing historically?
Yeah, thanks. I'll quickly hit a couple of these things, and then we'll carry it over to the next session. Our legislation requires us to consider prior record score, so that's sort of built into the mix. But even without that, the research on sentencing guidelines generally across the nation generally see prior record score as being included for one of two reasons: either because it's some kind of measure of the blameworthiness of the individual, the person's back in the system again, or it's an indication of risk of future offending. And that's why some of our research, when we're looking at prior record score, we're trying to look at these individuals and what their recidivism rate is, and is the rate different based on the prior record score category. So we include it because we're required to. We think at least staff thinks maybe we are a little too aggressive in use of prior record score, and it's worth considering. But there are some legitimate reasons for having a prior record score. I think the other thing we'll just leave for the next session, if that's okay with you, get to that. So we're going to take a break.